My name is Amy Coates. I'm an immigration attorney with Bachelor's Bureau Immigration Law Group in Raleigh, North Carolina. I'm here with our managing partner, Ravi Basham.
Hello, Amy.
We are going to talk today about I-9 forms and Social Security no-match letters. This is just going to be an overview of the basic issues in this area that we see that come up in our practice. And then if you have more specific questions that we can't answer during the time limits of this webinar, you're welcome to email us or contact us afterwards, and we will try to address those problems individually. This is just an outline of the things that we're going to discuss today. First, I'm going to hit the basics of I-9 forms, which a lot of you who are listening probably are already aware of these things. We're going to talk a little bit about knowledge, actual versus constructive knowledge. This is the thing that gets employers into trouble. Also, we're going to talk a bit about audits, violations of I-9 regulations, and penalties that could be imposed upon an employer. And we're going to talk a bit about what we believe employers can do to help themselves to be proactive here. And then finally, we're going to hit on the no-match letters. So the I-9 form is the form that employers are required to have completed and keep on file for any employees that they hire. Now, this does not apply to independent contractors. This is just for employees. The I-9 form is divided into 3 sections. The first section has to be completed by the employee. However, it's the employer's responsibility to make sure the employee has completed the first section correctly, meaning that have they filled it in the proper box, have they answered every question. And also, it's also the employer's responsibility to make sure that, is this someone who understands the first section? If they need a translator, then you need to provide one for them and make sure that that's done completely. This needs to be completed within the first day of employment. Sections 2 and 3, those are completed by the employer. This is where the employer reviews the documents that the employee presents and records certain information about them in Section 2. And then the employer signs off at the bottom in Section 3. Now, the employer cannot specify which documents that they will consider. And just remember that there is a chart that shows the different documents that you can look at, but there's always a few unusual situations. And if something looks unusual, then you need to look at the instruction manual for the I-9 to make sure it's not covered.
And as far as the documents themselves, as long as they reasonably appear on the face to be genuine and relate to the individual who presents it, they should be authentic.
That's right.
Or considered to be authentic.
That's right. The other thing is you have to decide for your company whether or not you're going to photocopy the documents that are presented, or if you're not going to keep any photocopies. But you should do one or the other.
What if an employee shows up and they say, well, we're going to present a list B or a list A document, and they say that it's been stolen or lost or something,
right,
and they present a receipt?
Yeah, and in some circumstances you can't accept a receipt for up to 90 days. And that's one of the things that I mentioned. If an employee tries to present a document or receipt like that and it doesn't fall neatly into columns A, B, and C on the document list, then look at the I-9 manual, because they have some really good Q&As in the manual that address issues where some unusual documents are presented. And a lot of people aren't familiar with these documents either. And so the employee very well may be presenting something that's completely fine, but because you may not be familiar with the document, it's just a good idea to check it out. Make sure that you're only accepting original documents. You should not be accepting photocopies, only unexpired documents. Now, in the past, there were occasions years ago where you could accept certain unexpired documents, but that is no longer. Okay, as far as retaining the forms, again, I did want to mention again about the photocopying. If you're going to keep photocopies, keep them for all employees and keep them with the forms. Retain your forms. You can have an electronic system for your I-9s, and there's some special guidance on that within the I-9 manual. I'm not seeing a whole lot of that yet, but...
And as far as actually retaining the forms, also you have to retain them for either 3 years after the date of hire or 1 year after employment is terminated, which is a heck of a calculation to make from
And
an
it's
employer.
whichever is later.
Whichever is later,
date
exactly.
goes to. Finally, unlawful discrimination does come up in this situation on many occasions. There are some folks who are just very overzealous with their I-9 practices. I mean, you can't, if you're hiring a foreign national, you can't just, for those people, keep copies of their documents, but not keep copies for the U.S. citizens. Or you can't scrutinize documents more closely just because someone's from a foreign country.
That's exactly right. And as Amy mentioned earlier, you also just cannot ask for specific types of documents based on someone's nationality, because that would be considered discriminatory.
Well, thank you so much for joining us today. We really appreciate it. And again, just let us know if you have any questions in the future.
Thank you.
Bye-bye.